Picture this. Your business is underway. Great technology, lots of customers, new ones coming in every day. But then, unfortunately, you get into a dispute with a customer. It's serious. They sue you for $10 million. Well, it turns out you were operating as a sole proprietorship. Now your house is on the line, all your personal bank accounts. It might just be all over. You probably forgot to ask yourself at the beginning the most important question that a business owner can ask before entering into business, and that is, what type of business entity is right for your business? Hi, my name is Amanda Paracuellos, and I'm a partner at the law firm of Crowell Moring. Crowell Moring is a proud sponsor of TriTech, and I work with many emerging company clients in my practice area, which is corporate and securities. Today, in this presentation, I'm going to address one of the first questions I'm often asked by my emerging company clients, and that is, what type of business entity is right for your high technology business? I'm going to give away the answer right up front, so don't go away. The most likely answer is that you should form a Delaware C corporation for a high-tech, high-growth startup business. But let's take a step back and find out why that is. We'll start with the basics. What is a business entity? I like to think of it as a fictitious person. Think about it. Companies, just like people, can borrow money, they can enter into contracts, they can sue people. There are many different forms of business entities you've probably heard of: partnerships, limited partnerships, but we're going to focus mostly on corporations and limited liability companies for purposes of this discussion. So why do you need a business entity? Well, the primary purpose of creating a business entity, back to the story I told you at the beginning, is to shield the owners from liabilities that can arise from their business. If you conduct a business as a sole proprietor or an unincorporated group, you're liable personally for all of the activities of that business and all of the liabilities that it incurred, and if you have partners, all of the activities that they engage in as part of the business. However, if you operate with a corporation or a limited liability company, your liability is limited to the exact amount of cash that you contribute to the business. For example, you form a new corporation, you contribute $1,000 in exchange for stock. You become a shareholder. That business, like the one I talked about at the beginning, is sued for $10 million. It goes out of business, it's bankrupt. The worst that can happen to you as an owner is that you've lost that $1,000. The injured parties cannot make claims against your personal assets and can't force you to put any additional money into the business. So, what is the difference between a corporation and an LLC? Well, both corporations and LLCs provide for the limited liability that we just discussed. So, the main differentiator is taxation. Simply put, a corporation's profit is taxed twice, the double tax. It's taxed at the time that the corporation receives the profit, and then again, when the corporation distributes the profit to its owners pay tax on those dividends. However, with an LLC gets what's called pass-through treatment. Pass-through treatment means that the LLC is disregarded by the IRS, for example, for tax purposes, and the profits of the company are automatically attributed to its owners. Sometimes a related benefit is that losses of the company in an LLC are also passed through to its owners, so they can use those losses to offset other sources of personal income. However, one drawback can be that if you are automatically allocated a profit, but you're not distributed cash to cover the tax, you can have a mismatch between the profit that you've realized for tax purposes and cash you may have in your pocket. Quick aside about S corporations while we're talking about taxes. Corporations come in two different flavors for tax reasons only. It's C and S. A C corporation is the default rule that we've already discussed with double taxation. Certain corporations, if they fit the rules, can qualify to elect S status, and that effectively gets them the pass-through treatment, which would be similar to an LLC. Due to their own internal organization and tax interests, VC firms do not find the pass-through treatment offered by an LLC to be beneficial to them. Thus, they prefer the C corporation. Venture capital firms also value the predictability and so prefer to invest in corporations because they are subject to a well-established body of law and are well understood. And they've just been around for longer than LLCs. So if you have your sights on venture capital funding, the C corporation is probably the only choice. There are a couple of secondary reasons to choose a C corporation as well. First, High-growth startups typically need to provide stock options to their employees. It's a very important way to provide compensation when cash is scarce. There's just no simple way to do this in an LLC. Second, corporations tend to be simpler to organize from the legal and practical perspective, which makes them easier for owners and investors to understand and work with. It also reduces legal and accounting costs relative to the costs that are typically incurred to operate an LLC. So we've talked about why a C corporation is the choice, so now let's get to why Delaware. States and state laws govern the establishment and governance of business entities in the United States. This is why each state in the country has its own set of corporate laws for this purpose, and this is why business owners must choose the state law under which they wish to organize. Most of my clients have narrowed it down to Delaware, California, or Nevada before they even come to me. Delaware is the default choice for many reasons. Delaware long ago set about to develop a corporate-friendly set of laws and a court system that would become expert in resolving corporate disputes. As a result, Delaware has become the state of choice for public and private companies alike. Many of my clients ask me, but what about Nevada? I thought I could avoid state tax if I incorporate in Nevada. This is just really not true. Corporations have to pay tax in whatever state that they do business, where they have their operations, where they make their money. So for example, if you form a corporation in California, you operate in California, you're selling products in California or any other state, that state is going to tax the profits that are allocable to their state. So unless you're really operating only in Nevada, you don't get the benefit of incorporating in Nevada that people usually think that you do. So there you have it, an explanation of why Delaware C Corporation is the likely answer to the choice of entity question. Of course, every business is different, and entrepreneurs should always seek the advice of a qualified lawyer in order to ensure that they make the right decision for their business. Thanks for listening. For more information, I encourage you to visit our website at www.crowell.com.